that delayed us with that 8 minutes. I profusely apologize. That is not in any way manner to disrespect the Commission.
You said something about communicating. What did you say? I think you said communicated. Or did I mishear?
Sorry, Commissioner, I didn't get that clear.
I thought somewhere in what you were saying, you said something about having communicated. Did I mishear?
Yes. Since at about 7 o'clock this morning, I've been in communication with the attorneys of the Commission, also in terms of exchange of documentation, where they haven't received necessary documentation.
Did that have anything to do with the possibility of you being late?
Yes, my colleague did communicate. He's just outside, but I will give you that. I can be able to give the details in terms of who exactly should communicate that we're running slightly late, or we might.
But in any event, Mr. Ngwato, you knew that you had to be here at 9:30. I do not understand why you would have had to go to the High Court personally. Surely you have other people in your law firm who could do that. And that's a very simple, attending to court and making sure that the matter is properly registered, assigned a case number and all that. That's a very minor, yes important, but very minor administrative issue, which could be done by anybody. It could even be done by administrative people who are not legally trained. Why it should take the owner of the firm, I assume you are the owner of your law firm, to go there and attend to this, it just does not make sense at all to me. For you to then make us wait for you, for something that could be done by someone else. For example, last week, you were there with Mr. Please remind me. Mr. Malika. You were there with Mr. Malika. Why could Mr. Malika not attend to that? Or whoever else for that matter. This is totally unacceptable. Totally unacceptable. It's actually unprofessional conduct to make us wait. Why did you not communicate with Mr. Shaskalsen?
Mr. Commissioner, like I indicated, that I've been in contact with the attorneys.
Why did you not communicate with Mr. Shaskalsen?
I don't have Mr. Shaskalsen's direct number.
You were communicating with the Commission's attorneys. You could easily have gotten his number from them. That's not an excuse.
Commissioner, maybe if I'm given a chance to respond, then the Commission will appreciate.
Yes, go ahead, please. Go ahead.
Thank you. As of yesterday, Commissioner, I have 6 times called DM attorneys, and I spoke to Mr. Mbao to give me the number of Geraldine Berger, who I know and have been introduced since the beginning of this proceedings to be the person, to be the contact person. For the entire day, I was not given those numbers. This morning, I spoke to the main director of DM attorneys himself, and I indicated my disappointment that their law firm, since yesterday, I've been communicating with one of the officials just to get through to Geraldine Berger, and I could not get those details. I was quite very happy when I now deal with the main director, and we started exchanging since this morning. We're traveling with one car. When we were just about to arrive, and there was requested to have a copy of the High Court, I indicated to Mr. Mokhasho that for some reason since this morning, my phone cannot open PDF documents. So I'm waiting for Mr. Malika to come outside court. I'm standing outside court so that I can send the necessary documentation to him. Unfortunately, in this particular instance, there was never any malice or any intention on our side to disrespect the Commission. I've been up since 6 o'clock this morning dealing with this particular matter. We left our office 2 o'clock this morning.
Mr. Ngwato, I will say this, and I do not want us to engage any further on it. What you say from where I'm sitting are excuses that are totally unacceptable. I maintain what I said earlier, which is that knowing that you had to be here at 9:30, there was no reason for you to attend to a minor, yes, important administrative issue that could have been attended to by anybody. Totally unacceptable. The discussion is closed.
Well, we apologize for that, Commissioner.
Sorry?
We apologize for that.
Thank you.
Thank you.
Yes, Mr. Shaskalsen?
Chair, Mr. Ngwato was going to move a postponement application.
Yes. Mr. Ngwato, we have before us your postponement application. Can you proceed to move it, please?
Indeed. Commissioner, I must appreciate and thank the Commission for having granted us the postponement last week. And indeed, we definitely used of the time to the best of our ability as was granted since last week. However, since we started finalizing the documentation, certain things really cropped up and showed and changed the direction that we were taking, which therefore since necessitated this application. As it's commonly known, we are the creatures of instruction. It's our client instruction then to bring an urgent application in the Higher Court, purely and solely for two reasons. As the Commission is in possession of the papers, I take that the papers might have been read and apologize that they've been submitted to the Commission almost on the 11th hour. The first reason, Commission, is the same reason, one of the reasons that we mentioned last week, that the applicant, before he could even make his first written submission to the Commission on the 17th of December, an interim report was already been issued, which we fully understand and correctly so in terms of section 10.4 of the terms of reference, that the Commission is entitled to do so. But 2 days before he could even make his first written submission, an interim report has already been issued, which had recommendations and findings and recommendations against him. Unbeknown, and obviously we do not have access to that particular interim report, but just a day before our appearance on the 30th of January, which is last week, Friday, the state president publicly announced that he accepted the same report, and therefore an announcement was made that he needs to be charged. It is on the basis, that's the first reason, it's on the basis of that is of the view that even though at the Commission he is a witness, not an accused, but whatever he may be able to say as a witness at the Commission he may incriminate himself, which will be a violation in terms of Section 35(3) of the Constitution. The second aspect that made us to then make the application to the High Court, Commissioner, is that in perusing the WhatsApp charts, the nature of the WhatsApp charts and the manner in which they've been extrapolated, it only shows outgoing and incoming. Even messages that were not originated by him, but he received them when they were forwarded to him, appears to be that he's the originator of the messages, which now distort the narrative and the version and how things are in terms of those messages. And as a result, that will then necessitate that he now gains access. I apologize. That will now necessitate that we look into how the messages were extrapolated in terms of, from his phone, in terms of from the time it was taken.
Feel free to either put it on silent or switch it off. Don't feel any pressure not to do that.
Mr. Commissioner, it's not even my phone, it's Mr. Maleka's phone, and I don't know his password or his pattern, how to close it off.
No,
so mine is here, and this is Mr. Maleka's phone. Is Mr. Maleka's phone ringing?
All right, thank you.
So in the manner in which how this, the chain of evidence, or the chain from the time his phone was taken.
Is that Mr. Maleka? Please go across.
Sorry. Yeah.
Are you no longer comfortable to support your post the way you did last week, Mr. Maleka? All right. Please continue. I'm sorry about the interruption, Mr.
Thanks, Commissioner.
Yes.
So the manner in which the charts were downloaded or extrapolated from his phone leaves much to be desired, which appears to be a violation in terms of how the evidence is being presented, because it doesn't show the messages that are forwarded. It doesn't show that he received it as being forwarded to him, but it shows as if he's now the originator. And some key people or chats that he had with other people are not included in that. And I quite understand that the evidence leader said there were certain messages that are not of interest. But for a consistency basis, in particular, he's been much more in communication with one particular general and as opposed to the other. But and the things that they were discussing with the other are not included. That shows a wrong narrative or misplaced the whole view of the situation. And as a result, it was my clients obtained a legal opinion from 2 SC senior counsels, who then are the ones that are currently working on the application in the High Court, with a junior counsel based in Durban. These took place as a matter of one day, having to go through this thing. And it is on that basis that if he is to come before this commission, whatever he says may not change because of, before he could make the first statement, an interim report was made. Before he could even appear, the president has already accepted that. So whatever he comes here and says may not change the narrative. And more likely that he will incriminate himself in any answer that he gives. And it's on that basis that that the applicant decided to launch an application in the High Court to restrict this commission, not to compel him to appear and not to compel him to answer any questions until pending the finalization of that application in the High Court. Thank you, Mr. Commissioner.
Thank you, Mr. Ngwato. Mr. Ngwato, I read, because I received the application only this morning, I read it hurriedly and I may have either missed or misread what I'm about to raise. I don't remember in the affidavit a point being made about WhatsApp chats that appeared to have been initiated by the witness when in fact they were not. Did I miss that? Or is this something you are stating for the first time from the bar, as it were?
Commissioner, I was just trying to elaborate on the reasons that I given. Because the first ground of him wanting the High Court to interdict is that his WhatsApp chats should not be displayed because those WhatsApp chats are not correct. They are incorrect in the manner in which they have come from because the entire bundle of documents, they only show outgoing and ingoing. Even the WhatsApps that somebody forwarded to him, and he sent it to somebody, it only shows that he's the one sending and making him the originator, while he's the actual fact not the originator of the message. Okay.
With the exception of what you are raising from the bar, my reading of the application is that the only new thing that's being raised in the application affidavit is the issue relating to Section 35 of the Constitution. The rest is something that the applicant ought to have raised in his postponement application moved last week. Do you agree with me?
May you please repeat?
I'm saying I read the application, today's application, to raise only one new issue, leaving aside the point that you are making from the bar. And that one new issue is the issue relating to Section 35 of the Constitution, the right to a fair trial in the context of a criminal trial. That's the only new thing that I saw in my reading of the application. The rest are issues that the applicant ought to have raised in his postponement application that was moved last week. What's your comment on that?
If I understand you, Commissioner, is that the things that are mentioned in the current application, is the Commissioner saying most of them are the things that were raised in the previous application?
Are the sort of things that could and ought to have been raised in last week's application. The exception is the Section 35 issue. That, on my reading, is the only new issue.
I differ, Commissioner, and maybe let me explain myself in terms of maybe try to find out common ground between the two. When we moved the application last week, it was simply because that we had not had time to peruse. Now, the time to peruse obviously goes hand in hand in the manner in which we received the documentation. But on further perusal of the matter, these things now become very clear. That Section 35, subsection 3 rights will be highly affected. But it all emanates also in terms of how he has been served right from the beginning. So there's a lot that starts and giving context from the beginning of how he received the notices and the ultimate aspect, if I'm making myself clear.
Yes, Mr. Ngwato.
And maybe just to conclude, Commissioner, we obviously gave the client a legal advice in light of the Zuma case, and I'm quite aware that the Commissioner is quite vested with that case, if not that participate in that case. And we had to distinguish between the rights of an accused as opposed to the rights of a witness. Because you could not invoke the right to remain silent because he's not an accused in here, he's actually a witness. But as a witness that is already being charged, is more likely to incriminate himself, which now prejudices his rights. And hence the focus in terms of that is the Section 35, subsection 3 rights that could be violated.
Thank you, Mr. Nkosi.
Thank you.
Thank you. Mr. Shaskalsin.
Thank you, Chair. Chair, this application needs to be seen in the light of the chronology. The witness has known he has to give oral evidence at this commission since sometime in November last year. He knew about the date of 30 January more than 2 weeks ago. He was provided with all of the WhatsApps that have been made available to the commission on 22 January. That was 12 days ago. He has no basis from preventing the Commission from having regard to those chats and from confronting him with those chats. But if he wanted to do so, if he wanted to bring some application in that regard, the time to launch that application was 12 days ago. He chose not to. Instead, he delayed until 28 January, that was 2 days before his hearing date, and sought a postponement of hearing so that he and his attorney could work through the WhatsApps. He brought his postponement application on 30 January. It was moved on 30 January. By that time, he knew about the recommendation in the interim report, but he elected not to address it in his postponement application. He successfully derailed the hearing set down for 30 January and was given a postponement to today. Then this morning, he brings a new postponement application, and this one is linked to a High Court urgent interdict application that he's apparently now served, and that in draft form was attached to the postponement application. According to the draft notice of motion, the High Court application is to be heard on 10 February. That's in a week's time, so it would derail any prospect of him testifying this week. The relief sought in the High Court application is framed in a confusing fashion. Prayer 1 is relatively simple, it's the urgency prayer. Prayer 2 is a prayer for an interim interdict restraining the Commission from compelling the applicant to appear before the Commission until, quote, finalisation of this matter. Prayer 3 is a prayer for an interim interdict restraining the Commission from exhibiting the applicant's WhatsApps pending, quote, finalisation of this matter. So 2 and 3 seem to be prayers for interim relief. And what are they contingent on? They're contingent on prayer 4, which is the prayer for final relief. And that's a prayer for an order reviewing and setting aside the notice in terms of Regulation 10.6 and the summons directing the applicant to appear on 30 January. So they want those 2 documents or instruments set aside. And they want them set aside because they were issued, quote, whilst having issued an interim report to the President with findings and recommendations against the applicant on 15 December, and which the President implemented on 29 January, which is contrary to the rules of evidence and principles of fairness. So it seems to be this new fair trial complaint. And that's the final relief. Now, the urgent is a complete abusive process. If it was going to be brought at all, it should have been brought long ago, and certainly before last week's postponement application. But in particular, the prayer for interim relief preventing the Commission from exhibiting the witnesses' WhatsApps is utterly hopeless, because it is completely unrelated to the prayer for final relief. Even if the witness were to obtain the final relief in prayer 4, there is nothing that would prevent the Commission from exhibiting his WhatsApps. The ordinary rules of evidence in courts don't apply to a commission. Rule 6.1 expressly states the Commission may receive any evidence that is relevant to its mandate, including evidence that might otherwise be inadmissible in a court of law. These WhatsApps are extremely relevant to the mandate of the Commission. In my view, they are more relevant than any evidence that has ever come before this Commission thus far. So whether or not the witness ever gives oral evidence at the Commission is entitled to have regard to the WhatsApps. And in view of their extraordinary relevance, it's not just a matter of being entitled to have regard to them. The Commission is obliged to have regard to them. Having said all of that, there is another issue, which is the fair trial complaint that is advanced now is itself stillborn for two reasons. The first is the regulations and the Commissions Act make clear that the witness has a right of privilege against self-incrimination in these proceedings. So the witness can refuse to answer any question that is potentially self-incriminatory. The second is that any evidence that the witness gives in these commissions is inadmissible in a criminal trial. So the fair trial complaint is a non-starter. But despite all of that, and despite the fact that this application and the postponement application are, in our view, abuses of process, we are willing to accommodate the applicant to a limited degree. What we propose is that we will not ask the applicant to answer any questions until his High Court application is finalised. However, we will not refrain from exhibiting his WhatsApps. Rather, we will use today and the remaining days that we would have used to hear the evidence of the witness, instead to display his WhatsApps and to explain their significance. If at the end of that process and after the High Court application, the applicant wants to give evidence to refute any of the inferences that we will in the course of the next few days ask the Commission to draw from the WhatsApps, he's welcome to do so. We undertake that if he wants to come back and testify to clarify any wrong propositions that we have put to the Commission, wrong inferences that we've drawn, we will ensure that he has that opportunity. There's another issue that I should just mention, which is that he has never previously expressed any concern about not being told which of the chats are forwarded and which of them originate from him or from the counterparty. If he had, we would have given him a spreadsheet for each set of chats which says which are the forwarded chats, which are the originating chats. He now raises that complaint. If he wants that information, we're happy to give it to him before he decides whether or not to come back to testify. But what we're not happy to do is to allow the process of this Commission to be derailed again. So our submission is that this postponement application should be dismissed, subject to the condition that we will not expect the applicant to answer any questions in respect of the WhatsApps that we will be displaying today, tomorrow, and possibly later this week. Those are our submissions, Chair.
Thank you, Mr. Chaskelson.
Mr. Chaskelson, can I just to clarify, I mean, if a postponement is refused, the witness is not excused. He has to remain in attendance, otherwise we are confusing. We refuse a postponement and then we excuse him. If it's refused, it seems to me that he would have to remain in attendance until he's excused by the chairperson. But if he remains in attendance, sitting, which I think he must, sitting in the witness box, it's entirely up to him how he wants to participate. Yes, he will be sitting remotely as was permitted with the last application. But as long as he remains in attendance, you will do the exercise. You will do your presentation as you wish to do, and it is really up to him how he chooses to participate. Because if he should decide, as he's sitting there, that he does want to engage with what you are presenting, we obviously can't stop him. But I just want you to be clear about that a refusal of a postponement. It doesn't follow that he gets excused. He's given leave to leave the commission. It means he remains in the commission until the chairperson says otherwise. And you're not suggesting that if that happens, if he remains in attendance, you you will simply present he shouldn't participate in the process. You're not saying that.
No. If he is entitled to participate as much or as little as he wants to.
Thank you.
Mr. Mwato, if you have any reply, but there are two specific issues that I would like you to respond to. First, the point made by Mr. Shaskalsin that the Section 35 point is still born for the reasons that Mr. Shaskalsin gave. I'm sure you remember them. And then, secondly, the exhibition of the chats and commentary on them, which is how Mr. Shaskalsin proposes to proceed today. So your comment on both those and whatever other reply you may wish to make, please.
Thanks, Commissioners. Commissioners, there were 4 aspects that I wanted to respond to based on the statement by Mr. Shaskalsin, and 2 of them actually emanate from the same aspect. The first one is that he says he's been aware of this when he was invited, and if he wanted to bring about an urgent application, he could have done so, even including in last week. And just to clarify that particular aspect, the applicant could not in any event, in anyhow, could have been aware and could have therefore acted, therefore. When the interim report was issued on the 15th of December, before he could even submit his first statement, he was not aware of the interim report. And the interim report is a confidential document that goes to the president. Nobody has an access to it. So he could not in any way been aware of the recommendations and findings in the interim report. Second to that is that even last week itself, I indicated in the last postponement application that just in the midst of preparation on the 29th, a day before, that's when the president made an announcement. And in that announcement, his name for the first time appeared. It is the only first time ever that he became aware. That was the night before he could appear in the commission. And second to that, or to support that, when we appeared on the commission on the 30th, we said, we have received this 4,800, now reduced to 1,300, but we have not yet finalized studying the documentation. So he could not have at that time appreciated what his rights and what his rights are because he had not even gone through the documentation. So it is incorrect to then suggest that had he wanted to bring this thing, the matter, he would have done so, and therefore there is no urgency in the matter. And that's the part that will be argued in the High Court in terms of when did whether the matter is urgent or not. That's the first comment with regards to the comments about urgency and when he became aware of that. The second aspect will also go together with the Section 35, subsection 3, in terms of the right to a fair trial. Is that now that he has have gone through the WhatsApp chats and now appreciate the veracity and the implications brought by these WhatsApp chats that he has now finalized yesterday, it became quite very clear that whatever answer, especially in light of this recommendation has been accepted, whatever questions they pose or whatever WhatsApp they display will implicate him in the next criminal proceedings that have already been approved by the state president, whether it's criminal proceedings or internal. So it greatly then affects the right to a fair trial in terms of him being able to, him possibly implicating himself. But also, I indicated that these WhatsApp chats, in the manner in which they've been extrapolated, which now the evidence says if there's a need for that, they could provide. They've been extrapolated or in an incorrect manner. And I gave an example of a WhatsApp that has been forwarded to him is now being portrayed as he is the originator of that WhatsApp. So even if you display them here, it will be misleading the country because it's going to be seen as he was the originator of that WhatsApp, whereas in actual fact he's not. And as a result of that, it then brought about in terms of whether the authenticity of these WhatsApp messages. Because how was the phone taken? What are the qualifications of the person who downloaded the WhatsApps? How truthful are these WhatsApp chats? Because in so doing again, will be a violation of his rights, because we already identified quite a great number of them that they were not originating from him, but they are now being displayed as they originate from him. Now, with that being said, is that this commission will then be failing its own mandate, because the mandate of the commission is that in terms of the terms of reference to their allegations, assess the information, and then make a determination if there's a prima facie evidence against a particular person. In this particular instance, decisions have already been made, recommendations have been made, but more importantly and central to that is how these WhatsApp chats have been obtained from his phone. It must also be remembered, Commissioner, when you received the first notice, it was not about WhatsApp chats from his phone. It was WhatsApp chats from somebody's phone. That's when he received the first notice and the summons. The only time he now receives WhatsApp chats from his own phone, and the evidence leaders testified about that, how they struggled to get the information from SAPS. They only got it last week, and therefore they were able to work it out. It was just last week. And therefore he could not have appreciated the nature of the WhatsApp chats any time before. He could not have appreciated the fact that you could bring an urgent application anytime before until the state president makes an announcement on Thursday last week, and he was to appear the next day. And to respond to the two aspects that you said, I must maybe have a look at it. That in terms of Section 35, is the right to self-incrimination. Is that those WhatsApp chats are just the same as any oral evidence or any type of evidence. They are incriminating, especially if the source of how it has been extrapolated is highly questionable, which now portrays him to be the sender, whereas in actual fact he's not the sender. He's actually forwarding what was sent to him. He's not the originator of the message. And in terms of the terms of reference of this commission, one is that the commission need to look in terms of how criminal or drug cartels have infiltrated SAPS. And if there is a message coming from a person that perceived to be part of the cartel and sent to him or forwarded to him, and now he forwards to somebody else, and now he looks as if he's the originator of that, that makes him to be participating or having facilitated in the organized crime. So there are far much reaching implications, and hence